ಹಲೋ ಕಾರ್ತಿಕ್, चल चल तुम नहीं चल 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 चल
ಹಲೋ
ಹಲೋ ಹಲೋ ಮೈಕ್ ಚೆಕ್ ಬರ್ತಾ ಇದೆಯಲ್ಲ ಸರ್?
ವಾಲ್ಯೂಮ್ ಜಾಸ್ತಿ ಮಾಡಿ.
ಮೈಕ್ ಚೆಕ್ ಹಲೋ ಹಲೋ ಕೇಳಿಸ್ತಿದ್ಯಾ ಸರ್? ಮೈಕ್ ಚೆಕ್ ಹಲೋ ಹಲೋ ಮೈಕ್ ಚೆಕ್ ಹಲೋ 1 2 3 ಮೈಕ್ ಚೆಕ್ ಹಲೋ 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 ಮೈಕ್ ಚೆಕ್ ಹಲೋ ಹಲೋ ಹಲೋ
ಸರ್ ಅದು ರವಿ ಕಟ್ಸ್ಕೊಟ್ಟಿದ್ನ
ನಾನು ಹೋಗಿ ಬರ್ತೀನಿ. ಹಲೋ ಹಲೋ ಮೈಕ್ ಚೆಕ್ ಹಲೋ 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 ಹಲೋ
ಹಾಗೆ ಚಿಕ್ಕದು ದೊಡ್ಡದು ತಂದ್ಬಿಡಿ ಇರಲಿ.
ಹಾಂ ಸರ್ ಸರಿ ಓಕೆ
ನೀವು ಹೋಗಿರಿ, ನಾನು ಚೆಕ್ ಮಾಡಿ.
ಓಕೆ.
I request all the participants, please kindly switch off your mobiles.
Hello.
ಸರ್ ಮೋಸ್ಟ್ಲಿ ಏನೋ ಮಧ್ಯದಲ್ಲಿ ಇಲ್ಲಿ ಕಟ್ಟಾಗಿರ್ಬೇಕು ಸರ್ ಮೈನರ್ ಇಲ್ಲಿ ಇದರಿಂದ ಪ್ಯಾಕೆಟ್ಸ್ ಲೀಕ್ ಆಗ್ತಾ ಇದೆ, ಎಲೆಕ್ಟ್ರಿಕ್ ಲೀಕ್ ಆಗ್ತಾ ಇದೆ. ಸೊ ಮಾತಾಡೋದು ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಮಾತಾಡಲಿಲ್ಲ ಅಂದರೆ ನೆಟ್ವರ್ಕ್ ಮತ್ತು ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಬರುತ್ತೆ. ಹಲೋ ಸರ್ ಜಾಸ್ತಿ ಮಾಡಿ. ಹಲೋ ಹಾಂ ಸರ್ ಫಸ್ಟ್ ಓಕೆ ಸರ್.
Hello. Mic check. Hello. Mic check. Hello.
Attention please. Attention please. The dignitaries are arriving. I request our director to lead Honorable Sri Justice V. Kameswar, Judge, High Court of Karnataka and Executive Chairman, Karnataka State Legal Service Authority, Bengaluru, to the dais. Thank you, madam. Good evening, and I welcome you all to the discourse on Commercial Courts Act 2015, the 7th in the KJA Silver Jubilee Lecture Series, a distinguished event that celebrates wisdom, ethics, and the enduring values of the Karnataka judiciary. The Commercial Courts Act provides more structured approaches to commercial cases by offering specialized judges with expertise in commercial law, along with clear timelines which enable quicker resolution. While the intention behind the Act is to foster efficiency, it is crucial that the effective implementation should be continuously monitored. Potential gaps, challenges to be addressed. In this connection, we as judges need to remain committed to continuously improving our understanding of the nuance of the Act. Therefore, the Karnataka Judicial Academy encourages all present here to actively engage in the discourse through interaction in order to ensure that Commercial Courts Act lives up to its potential in creating an environment where businesses can be tried, disputes can get resolved effectively, and justices can be delivered swiftly and fairly. To formally begin the event, may I request Hon'ble Sri Justice Srinivas Harish Kumar, Judge, High Court of Karnataka and Governor, Karnataka Judicial Academy, to kindly deliver the welcome address.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಗುಡ್ ಈವ್ನಿಂಗ್ ಟು ಆಲ್ ಆಫ್ ಯು. Honorable Chief Justice N.V. Anjarian, Justice Kameswar, all my brother and sister judges, all judicial officers, resource persons, invitees. In the Silver Jubilee year of the Karnataka Judicial Academy, today we have arranged the 7th lecture by Sri V. Kameswar, Justice Kameswar, the Senior Judge of the High Court of Karnataka. Today, the world is full of commerce.
All of us know that trade and commerce contribute a lot to the growth of a country. The growth of a country is measured in terms of GDP. It's needless to say that how important the commerce has in the growth of a country. So, when there is commerce and trade, disputes are common. Therefore, recognizing the need to resolve the disputes, Commercial Courts Act was enacted in the year 2015 to revolutionize commercial disputes resolution and enhance the ease of doing business. The core objective of the law is to instill confidence in the business community by ensuring timely adjudication of disputes. There are some complex issues in the Act which requires discussion. So today we have with us Justice V. Kameswar, Judge High Court of Karnataka, and a distinguished jurist to deliver the lecture. On this occasion, I firstly extend heartily welcome to our Chief Justice, Justice N.V. Anjaria, who has accepted our invitation and present with us to grace the occasion. Hearty welcome to my Lord. I extend hearty welcome to Justice V. Kameswar, who has accepted our request to deliver a lecture today. So on behalf of Karnataka Judicial Academy, the staff of the Academy, all the officers, judicial officers, I extend hearty welcome to Justice V. Kameswar. I also welcome my brother and sister judges, the judicial officers present here, the resource persons, registrars, and the faculty of the Judicial Academy. Lastly, I extend hearty welcome to technical team, support staff, and everyone present here. Thanking you all, I extend welcome to all of you once again. Thank you all.
Thank you, my Lord. On behalf of everyone, I extend a warm welcome to His Lordship, Honorable Chief Justice Srinivas Harish Kumar, Judge, High Court of Karnataka. As a tradition, may I now request Srimati H.R. Radha, Director, Karnataka Judicial Academy, to hand over pleasantries to Honorable Chief Justice V. Kameswar Rao, Judge, High Court of Karnataka and Executive Chairman, Karnataka State Legal Service Authority, Bengaluru, as a token of our respect. I also request Madam to hand over the pleasantry to Honorable Sri Chief Justice N.V. Anjaria. Thank you, Madam. May I now request Honorable Members of Board of Governors of Karnataka Judicial Academy to felicitate today's speaker, Honorable Chief Justice V. Kameswar Rao, Judge, High Court of Karnataka and Executive Chairman, Karnataka State Legal Service Authority, Bengaluru.
Naveen. Sir, laptop time.
Ready, ready.
Thank you, my lordships. We now arrive at the important stage of this evening, the 7th Civil Jubilee Lecture. Honorable Chief Justice V. Kameswar, Judge High Court of Karnataka and Executive Chairman KSLSA Bengaluru, is an eminent legal expert known for his profound knowledge and insightful lenses of commercial law. We are truly privileged to have his lordship with us today. It is my privilege to request his lordship to deliver the 7th lecture in the KJA Silver Jubilee Lecture Series on Commercial Courts Act 2015. Please, my lord.
Just take it, keep it at the bottom. Honorable the Chief Justice, Justice N.V. Anjaria. Chief, I am really privileged and honored because of your presence here, Chief. And all my brother and sister judges and all the judicial officers who are present, including the principal districts and sessions judges, everyone. Well, I am not going to give a big lecture. I am just here to broadly tell you through my experiences, holding the commercial court roster around in 2017 and 18, and sitting in division bench also in Delhi, where we used to get matters, be a appeal under Section 37 of the Arbitration Act or even the intra-court appeals within the High Court. And I'm sure that the Act being in vogue since 2015, and most of the judicial officers who are present here surely be well aware of the working of the Commercial Courts Act. So in that sense, what I will be talking is nothing new. It is something in a way that I would be sharing with you the experiences you have in the working of the Act and I have in the working of the Act. I just want before that, if I can ask how many officers today, as on today, are holding the commercial court roster? Amongst all of you who are sitting here. Anyone? You can raise your hands, that's enough. Acha, okay, very well. It's all right. So you be ready to answer the questions which may come, not from me, from the others. Before I just, come to the provisions of the Act, I just wanted to, in fact, the introduction which has been given on this has been apt. The introduction was what was the real objective for bringing this particular Act, and this can be clear in terms of the Law Commission report of the year 2003, which you can see on the Yes, this Law Commission report, in fact, its suo motu took the issue of Constitution of commercial divisions in the High Court as a result of, and the objective was need for a speedy disposal of high-value commercial disputes, need for reassuring domestic and foreign investors. This was the time, when we were expecting direct investment will come. And I recollect also when this act had come, there was the necessity felt that to improve the infrastructures of the court so that the commercial courts are established. And that's how it started in Delhi initially. And very well, it's change of economic policies in the country post 1991. And need to attract business at international level and to promote ease of doing business. The impression was, any litigation in India takes time. So we must ensure it, bring out some particular provisions which deals specifically with the commercial disputes, and the time consumed in the litigation is reduced. And effectively, this act had come on 23rd of October 2015. Yeah, these were the objectives, to bring out the act to improve India's rank in the ease of doing business, to ensure speedy and convenient and efficient dispute resolution, to promote growth of FDI and public-private partnership, to establish strong and responsive legal system. This judgment of the Delhi High Court deals with all the very purpose of bringing the Commercial Courts Act in extensively. Now, I just want to take you to the hierarchy of courts which are contemplated under the provisions of the Act. Now, insofar as Karnataka is concerned, we have commercial courts at two levels. One at the district courts and one at the appellate division in the High Court. Now, the commercial courts in fact, the initial, I think, the information I have, the commercial courts initially were established in 2018, two in Bengaluru and one in Bellary. I think for the simple reason that there were not much of a commercial court litigation at that time. Commercial court litigation, as is contemplated under the Act when it was put in, was implemented. So we had two courts established in Bengaluru and one in Bellary. Then commercial appellate division in the High Court, that's basically, these courts are manned by division benches at the High Court level. All the appeals from the commercial courts, they come to the appellate division. So we are only concerned, insofar as Karnataka is concerned, commercial courts at the district level and commercial appellate division in the High Court. Unlike, if you see at the bottom, there are high courts which have original jurisdiction at the High Court level. In those cases, there are commercial courts at the district level. There would be a commercial division having one or more benches of a single judge in the High Court. So, example, in Delhi, any litigation, in any case, insofar as the commercial litigation is concerned, it is anything above 3 lakhs now is the commercial litigation. But in Delhi High Court, anything above 2 crores was, the High Court was having the jurisdiction. So anything above that would be going to the learned single judge, and then intra-court appeal, like, orders passed by the single judge, it comes to the appellate division. This is the hierarchy of courts. Now I come to the jurisdiction of a commercial courts to try all suits. Yes. Generally, insofar as jurisdiction of a court is concerned, we have to see the territorial jurisdiction, pecuniary jurisdiction, jurisdiction with regard to the subject matter of the issue before the court. That's basically is the issue. And the provisions also contemplate that the provisions between 16 to 20 of the CPC would determine what kind of a suits that can be filed. And if you see 16 also, suits to be instituted where subject matter is situated. That is the jurisdiction of a particular court. If you turn over, if you see the section 17, suits for immovable property, these are all those provisions which determine the jurisdiction of a particular court or a civil court. Place of 17, suits for immovable property situate within the jurisdiction of different courts. Place of institution of suits where local limits of jurisdiction of courts are uncertain. Suits for compensation for wrongs to person or immovable. Other suits to be instituted where defendant resides or cause of action. This is section 20 of the CPC. Now, initially when the act was put in action, was implemented, the provision which was relevant for determination was a section 2 is there which defines 211, which defines specified value. There are two things which is required to ensure that maintainability of a commercial suit. The first requirement is it should be a commercial dispute. That I will take you later once we are through with this. The second is specified value. Any value of a suit which is more than 1 crore at that relevant time became the subject matter of a commercial suit in a commercial court. But the government bought an amendment in the year 2018, 3rd of May 18, 2018, whereby the specified value was reduced to 3 lakhs. So all those disputes which are more than 3 lakhs became the specified value, where specified value of a suit which can be filed in a commercial court. Now, how to determine the specified value of the commercial dispute is this: where the relief sought in a suit or application is for recovery of money, the money sought to be recovered in the suit or application, inclusive of interest, if any, computed up to the date of the filing of the suit or application, as the case may be, shall be taken into account for determining this specified value. So what it contemplates is, what is the relief you sought? If it is a recovery of money, the money sought to be recovered, and the interest, if any, computed till the date of the filing of the suit. So what it follows is that pendentolite and a future interest would not be taken into consideration for determining the specified value. Similarly, if you see the B, where the relief sought in a suit, appeal or application relates to movable property or to a right therein, the market value of the movable property as on date of filing of the suit, appeal or application, as the case may be, shall be taken into account for determining this specified value. This is in the context of the movable property. Now, if you see C, where the relief sought in a suit, appeal or application relates to immovable property or to a right therein, the market value of the immovable property as on the date of filing of the suit, appeal or application, as the case may be, shall be taken into account for determining the specified value. This is in the context of immovable property, because you have to determine the immovable property, what is the worth of that immovable property, so that you come within the definition of specified value. So this is now D. You will see where the relief sought in a suit, appeal or application relates to any other intangible right. When we are talking of intangible rights, we are talking of the rights in the intellectual property, like trademark, patent, and copyright. Appeal or application relates to any other intangible right. The market value of the said rights as estimated by the plaintiff shall be taken into account. So this much discretion has been given to the plaintiff, because intangible right, unlike a immovable property and then movable property, you can't work out what is the worth of that intangible right. So it has been left to the discretion of the plaintiff to determine what can be the suit value, specified value. For this, the plaintiff will, maybe for the purpose of valuation, for the purpose of payment of court fee, he can really determine the specified value or value the suit and accordingly pay. But in the context of Karnataka, since the original jurisdiction is only at the civil court, it would not make much of a difference. But unlike in Delhi, where the 2 crores and above comes to the Delhi, then this valuation becomes important. And I have seen from experience that most of the IPR litigation comes to the High Court because the stakes are high, and they try to value the suit more than 2 crores so that the jurisdiction comes. So that discretion has been given to the plaintiff to determine it. Now, in the context of the arbitration, now we have seen what should be the manner in which the specified value to be determined. In the context of arbitration, the aggregate value of the claim and counterclaim, if any, as set out in the statement of claim and counterclaim, if any, in an arbitration of a commercial dispute shall be the basis for determining whether such arbitration is subject matter of jurisdiction of commercial division, commercial appellate division, or commercial court. I don't think this really makes difference insofar as Karnataka is concerned. Any claim or counterclaim cumulatively would be more than 3 lakhs only. So everything in any case would go there. And it doesn't make any difference because ultimately complete original jurisdiction is with the district court here only. Now, this is a very interesting provision where no appeal or civil revision application under section 115 of the CPC, as the case may be, shall lie from an order of a commercial division or a commercial court finding that it has jurisdiction to hear a commercial dispute under this act. What this provision contemplates is, this provision is under the heading of specified value 12. Now this says, where a court says the specified value as determined by the plaintiff is within the jurisdiction of this court, I will hear it. And that's an order passed by the court. Such an order is not appealable or nor a revision can be filed. And very interestingly, I have seen in the Commercial Courts Act, there are many provisions which bar a revision against any order. As we go forward, I'll tell you, there is a provision 13(1)(a) which specifies that appeal shall lie only to the extent which are stipulated under Order 43. Now the question had come, what would happen to those cases, those orders which are not contemplated under Order 43? Where will they go if a person is aggrieved of that? There is a bar under 8. There is a bar under section 8 to say that you cannot file an appeal. But that's a different issue which need to be looked into. Surely that will not really concerns the district court of officers, because that will be at the high court level because the appeal comes to the high court. That we will deal it later. Also, there are some judgments which have been given by the Delhi High Court and even the Maharashtra. The above does not depict. Now, what I have said is, you have seen in the previous slide that if you determine the specified value will be the recovery, the amount you are recovering, plus the interest on the date of filing the suit. These judgments say the above does not depict pendentellite and future interest as the basis for determining this specified value. So they worked out, you don't know how much you will get it. For the purpose of determining specified value, what is the money you are making a claim for, and what would be the interest on the date, that would determine, and this would not determine. These are the judgments on that particular aspect. Now, it says the specified value of the plaint has to be mentioned only to show the jurisdiction in which the suit has to be filed. Although this may not be relevant insofar as Karnataka is concerned, because every suit will come in the district court here only. Unlike, other jurisdictions where High Court has also a jurisdiction. So between the district court and the High Court, they must make a averment in the plaint that for what reason he is approaching here, and what is the basis for him to say that this would be the specified value, so that that higher court gets the jurisdiction. Now, if you see this, Commercial dispute must be of specified value. The plaintiff is dominus litis. Valuation must be disclosed in the plain. Court fee is not affected. Unlike the court fee which you pay for the normal, suit, that would be the court fee, valuation, everything that would be governing even a commercial suit. There is nothing different which has been brought in the commercial court for the purpose of valuation or the court fee. So that remains the same. If you see the third bullet point, court fee is not affected. And the next bullet point is 12.3 stipulates no appeal civil revelation. That I have already told you. Now, this becomes, you have seen specified value. That should be one of the criteria. The second is, what do you mean by a commercial dispute? And this issue is a subject matter of, a lot of litigation. Everyone says that this is a commercial dispute. Everyone thinks that any business transaction or any business relationship must necessarily be a commercial dispute. But the fact remains, under the scheme of the Act, that's not the position. Now we will see why. Commercial dispute has been defined in 2(1)(c) onwards. Now you see there are around 21 categories which have been mentioned here. Commercial disputes means arising of ordinary transactions of merchants, where a merchant is, dealing with the sale of goods, bankers and financiers who is, lending money, and traders similarly who is dealing with the goods, such as those relating to mercantile documents, including enforcement and interpretation of such documents, then export, import of merchandise or services, issues relating to admiralty, maritime law, transaction relation to all these things, carriage of goods, construction of, if you see 6, construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively for trade or commerce. Now this particular provision of 2(1)(c) has been subject matter of a lot of litigation also. In fact, now this issue has been settled by the Supreme Court in one context that I will take you to. Then franchisee agreements, distribution of licensing agreements, then management and consulting agreement, joint venture agreements, shareholders agreements, subscription and investment, mercantile partnership. Now you will see this, you have intellectual properties also, 17 agreements of sale of goods, exploitation of this, insurance, reinsurance. Now, if you see this, what happened? Now, 21 says contracts of agencies relating to any of the above. When we are saying any of the above means any contracts of agency from 1 to 20 would also be included in clause 21. Now, 22 is very important. Such other commercial disputes as may be notified by the central government. That means it is definition is exhaustive to the extent of 1 to 20, but there can be a possibility if the central government think that a particular category must be included in the definition of commercial disputes, it will be included by way of a notification. It means that commercial disputes only means what has been found mentioned at 1 to 20. At 1 to 20 and nothing more. Anything beyond 1 to 20 would not be a commercial dispute. It would not be. To that extent, one can say 1 to 21 is exhaustive, but at the same time, it will not be limited to 1 to 21 because 22 also contemplates that a central government can do it. So that's the reason the argument generally happens is advanced is, look here, I am in a business relationship with A is in business relationship with X. So for all purposes, this is a commercial dispute, hence maintainable. The courts have said, if it falls between 1 to 20, it would be a commercial dispute. Anything beyond that cannot be a commercial dispute. Otherwise, there was no reason for the parliament to say such other commercial disputes as may be notified by the central government. Though the parliament is conscious, there can be other disputes which need to be notified. That's the reason that power has been given to the central government. Now, explanation, you will see the explanation. As per explanation, a commercial dispute shall not cease to be a commercial dispute merely because it involves action for recovery of immovable property or for realization of monies out of immovable property given as security or involves any other relief pertaining to immovable property. So what it says is, it will not be ceased to be. I'll give you an example for this. Let's assume a property has been leased out, which is used for trade and commerce. And a person files a suit for possession. He says, lease is over, now give me my property. He may be seeking, it's a commercial dispute because it falls within the definition of within the definition of 7, agreements relating to immovable property used exclusively in trade and commerce. So it is a commercial dispute, but merely what it says is the relief is something more, something related to the something related to that particular agreement, but merely because you are seeking something more. As per explanation, a commercial dispute shall not cease to be a commercial dispute merely because it involves action for recovery of immovable property. Obviously, when the lease is over, he will seek the recovery of the immovable property. Or for realization of monies out of immovable property given as security and involves any other relief pertaining to areas of rent. Or suppose a person who has taken the rent, he has given a security that need to be given back. So it will not. So technically, strictly speaking, this prayer of seeking the recovery or possession of the immovable property may not be a commercial transaction strictly, but the main transaction being a commercial dispute, that's the explanation come. So in such cases also you can seek such a relief. Now one of the contracting parties is a state or any of its agency instrumental. This is only says is there should be a level playing field. You are a private person, very well you can. Even state will be on the same footing. So any commercial transaction by a state also would be governed by these provisions. That's the intent. See, this is one of the judgments. It says that commercial disputes are those which are defined, the definition of stipulated 21 kinds of transaction out of which may dispute may. Every dispute, though commercial dispute, without falling in any of the clauses cannot constitute a commercial dispute. So it necessarily must be within these clauses. There is a judgment. This is for the reason that clause 22 empowers central government to notify any other dispute to be a commercial dispute. So that's. One to 20, you can't say so it's a commercial dispute. The words arising out of expands the with about 21 transaction. Now this is why this arising out of comes is in terms of in terms of 21C. I'll just go back. Yes. The commercial disputes means a dispute arising out of all these transactions. Anything which arises out of all these transactions will constitute a commercial dispute. That's the intent. And this in a way expands the width of the 21 items which have been listed in 2C1. There is one judgment I just wanted to There is a recent judgment by the Supreme Court in the name of Ambalal. I think most of the officers must be knowing it. That deals with the facts of those cases were, it was basically a property which was leased out, and it was concerning for the use in trade and commerce. The question came, I think the person was not in actual possession of that property. The question came whether without being there in the possession of property, can it be said that he was using for trade and commerce? The Supreme Court has interpreted the word to mean, if you see the last bullet point, agreements related to immovable property must exclusively use in trade and commerce. Plaintiff must disclose it deals with trade and commerce. It is clear that the word used means actually used or being used and not ready for use. So that's the distinction which has been made. If it is ready for use, it may not come in. If it is actually being used, it may come in. But there is a very interesting issue also. This is it appears to be in the facts of this case. But in one of the cases, I think possibly Bombay, the property was in a zoning pattern of a particular city in a commercial zone. If it is in a commercial zone, there cannot be any dispute that that property has to be used for commercial purpose in the trade and commerce, because it can't be used for residential purpose. So now that judgment goes on this premise: if it is in a commercial area, it is meant for commercial use, meant for trade and commerce, and there can be a jurisdiction. That's one way of looking at it also. Similarly, there can be a possibility that the property is there. I am B. A was also having a lease. It was to be used in trade and commerce. He used it and vacated it. I am a new lessee and I have a contract with him. The possession has not been given. Can an argument be taken? Look here, insofar as I am concerned, since possession has not been given, you have not used it nor actually used it, because I am out of the property. The possession has not been given. The argument can be, possible argument can be, well, the person who was there earlier, he had actually used for trade and commerce. So the identity of the property, and this need to be seen from the perspective of the property. The identity of the property is for the usage in trade and commerce. That can be an argument. These are the eventualities one can really see. So I am just giving, this is what the Supreme Court has said in Ambalal. Means actually used or actually used, not ready for use. Now this one example, the transaction between the parties should have a color of commercial nature. Now what cannot be? Suit asserting right to title to a property or adverse possession in respect of immovable property may not depict commercial transaction for it to be a commercial transaction. Dispute between two brothers who are, fighting for the property. Maybe that property is being used for commercial, in trade and commerce. The Supreme Court says, and this example says that though it deals with immovable property, though the property is being for trade and commerce, but the dispute is not in commercial sense. It is some dispute intersect between the brothers. Hence, it will not fall within the commercial dispute. Now, the example 2 is, a recovery of mean profits against a tenant bank by the landlord is held to be a commercial dispute when property is being used for trade and commerce. This is basically pertaining to that definition at 7, all this. I will not really take much of a time on this. The other aspect is, which I feel, at least from the perspective of the, the original litigation which is filed before the civil court, is there is a very, after although this provision has been there since 2018, there is a provision, what happened? Yeah. This is pre-litigation mediation and settlement. This has been there, and we are all well aware also there is a pre-litigation mediation. Now, this section 12A has undergone a change because of the Mediation Act 2023 which has come. And this contemplates a mandatory, and it has been interpreted by the Supreme Court also in a judgment called partial automation, where the Supreme Court has said this is a mandatory provision. Everyone knows that. Now, previously this mediation was under the Legal Services Authority, but after the coming of the Mediation Act, the Mediation Act contemplates mediation provider. Mediation provider means there is a mediation council which will give recognition to all the mediation centers. The Legal Services Authority is one, and there is a court-attached mediation center. Those are also being given the power to mediate. Now, the question which arose before the Supreme Court was, one is, in any case, the mandatory nature of the provision. The Supreme Court clearly held it is a mandatory provision, you must go. But generally what happens is here, and everyone must have seen, maybe we have also seen, every officer must have seen, there is a tendency not to invoke 12A and directly come to the court and saying that, oh, I have certain urgent relief to be sought. And this has been the tendency. Now, this kind of a litigation effectively making the provision of 12A nugatory. OTOs means no one is really resorting to 12A. The result is the litigation directly comes. The intent was, look here, we can at least cut down the litigation if 12A is implemented, 12A is acted upon, or 12A is resorted to. This judgment and it's called Yamini Manohar, and I just want to read. This is very interesting. In fact, maybe I think all the judicial officers must have seen this also. The Supreme Court has said so. It's not merely, ultimately, as a plaintiff, I'm a dominus litis. It is my wish, I will file, I will pray. According to me, I want an interim relief. I'll go to the court, file a 39(1) and 2, saying that I'm praying for an interim relief. And it should be given. Because that discussion surely with me. But when you are considering such a petition, such a suit, where an application has been filed, though he may not be entitled or he may not require any interim relief, the Supreme Court says you have to see actually very closely what kind of pleadings are being made. Now, I would like to read this. And this would be, and I think possibly I request all the officers also, I think these need to be looked into very carefully in terms of what has been said by the Supreme Court. Now, Supreme Court says, we are of the opinion when a plaint is filed under the CC Act with a prayer for an urgent interim relief, the commercial court should examine the nature and the subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be in the disguise or mask to wriggle out and get over Section 12A of the Commercial Court Act. The facts and circumstances of the case have to be considered holistically from the standpoint view of the plaintiff. Non-grant of interim relief at the interim stage when the plaint is taken up for registration, admission and examination will not justify the dismissal of the commercial suit under Order 7, Rule 11. At times, interim relief is granted after issuance of notice, nor can the suit be dismissed under Order 7. Now, if you see the next paragraph, having stated so, it is difficult to agree with the proposition that a plaintiff has the absolute choice and right to paralyze Section 12A of the CC by making a prayer for urgent interim relief, camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and falsity is apparent or established. The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure of Section 12A of the CC Act. An absolute and unfettered approach is not justified if the pre-institution mediation under 12A of the CC Act is mandatory as held by the Supreme Court. So what the court has said is every suit or an application which is filed before the court, you must look into the averments very carefully, and to say that under the guise that he is seeking an interim order, he's not availing the remedy which is available under 12A. So this is one important provision and one important judgment. In fact, recently also, we have also given a judgment interpreting 12A also. And in that case, we have very interesting, this need to be, I think I need to tell you, generally I have seen here that a party files an application seeking exemption from availing the benefit, the provision of 12A. No such application is actually required. The very fact that the suit has been filed with an application for interim relief, it goes without saying that he doesn't want to avail 12A. So you have to see the suit and 12A and to see whether it is actually he requires an urgent interim relief. In our case, it was in the context of an, trademark. So trademark cases generally, see, I must tell you this. Whatever I am saying, you should not construe it as a view of a high court. Let's be clear on that. It's my view, that's my understanding, surely, when I am speaking here. So you will all look into the law, facts, everything, and take a call yourself. So now, 12A was not resorted to. In that case, it was a case of trademark. And obviously, any trademark cases, generally it so happens also, the person is wrongly using the trademark. Generally, plaintiff comes, he files an application for appointment of a commissioner for, those trademark infringing goods must be taken into possession. So otherwise, if he resort to 12A, by the time he'll sell all the infringed goods in the market, the purpose gets defeated. So that's why in such a cases, possibly yes. But every case needs to be seen in the facts of its own. See this this section is important. Any suit surely governed by the provisions of the CPC. But when this Commercial Courts Act had come, with the objective you have seen also insofar as the Commercial Courts Act is concerned, to ensure the objective is achieved of a Commercial Courts Act, certain provisions of the CPC were amended. This is only to ensure that there is a fast disposal of these cases also. Now those sections also include quite a few also. Starting from the affidavit that need to be filed, statement of truth, regarding costs, regarding, case management, regarding, provisions regarding filing of the written statement and filing of the documents. And insofar as the filing of the written statement is concerned, Supreme Court has said so also that is a mandatory provision. There is a provision 30 plus 90 days, total is 120 days. Beyond 120 days, who has not filed it cannot file it. He loses his right to file a written statement. I don't know whether the provision is there for filing a replication also. There is some, period given for filing of a replication that's around 45 days in other jurisdictions. So if you don't file your replication also in 45 days, you lose your chance to file a replication also. So that provision has been held to be mandatory. And similarly, what happens is when a written statement is filed, you have to file all your documents which you want to support it, which you are in possession of, it necessarily has to be filed. And coupled with, you have to file an admission denial of the documents which has been filed by the plaintiff by way of an affidavit. These are the things which have been brought out in the Commercial Courts Act. Now there is a very interesting provision of, costs. Section 35 has been substituted by the Commercial Courts Act with regard to the commercial litigation. And if you see the amended under the Commercial Courts Act, the Section 35, it enumerates in what eventualities you can pay a cost. Even cost can be paid at any stage of the suit. Suppose an application is filed which is a frivolous application. Surely you would be and you say it is a frivolous application only to delay the proceedings. You would be within your rights to impose, the court would be within its right to impose a cost. There are many factors. If you see 35 as amended, as brought in, you will get a clear idea as to in what circumstances you can file. You can impose cost. I think possibly I have one judgment. Very well. This is what, for all purposes, possibly you can go to, see Section 35. Costs, there is a provision under Section 35A, there is provision under Order 20A, and there is, I think, 35B also, there is a provision for costs. You can see those provisions also. And insofar as strict timelines are concerned, which I was just mentioning, Yes, these are, I was I'm referring to that, strict timelines. And Okutek is Delhi High Court, SCG contracts, that is Supreme Court, where the courts have said it should be mandatory. Then this amendments includes also this admission denial of documents that I have already told you. There are few judgments, I must say so, where suppose the defendant or a plaintiff has not filed the documents. Generally, the small narrow window which is available is such a document was not available with me. Now I have come in possession, I am filing it. That may be permitted. So in that sense, any documents which were filed earlier, though filed, there may be some documents which were not in possession, he wants to file it. That narrow window has been given, but subject to showing good cause and establishing it also. Generally, it so happens also, and I have seen it also. The basic ground they take is that this document which I am filing it, because once you file all your documents, your right is closed from filing further documents. But that window is still available, showing a good cause, saying that for this reason I could not file it. There may be documents which were not in your possession, and now you want to file it. Possibly that would be a good cause for you to file it later. Now, this is a provision which has been brought in for, disclosure and discovery and inspection of documents. I just read it. This will give a good, the picture of in what manner, in commercial suits that this provision need to be looked into. Plaintiff has to file a list of all documents and photocopies in power, possession, control, or custody pertaining to the suit. Specifying whether the documents are original or copies, must state the details of the parties to the documents, mode of execution, line of custody of the documents. The plaint has to contain statement of truth from the plaintiff that all documents in power and possession, control, or custody of the plaintiff pertaining to the facts and circumstances of the proceedings have been disclosed. Likewise, the defendant has to likewise file a list of all documents and photocopies in its power, possession, control, or custody pertaining to the suit, along with the written statement or with counterclaim, if any. Plaintiff or defendant, by leave of the court, may deliver interrogatories in writing for the examination of the opposite parties. Any affidavit in answer to the interrogatory has to be filed. Where any person interrogated omits to answer or answers insufficiently, the party interrogating may apply to the court for an order requiring him to answer or to answer further, or an order may be made requiring him to answer or to answer further, either by affidavit or by viva voce examination, as the court may direct. Now, all parties are required to complete inspection of documents within 30 days of the filing of the written statement or the written statement to the counterclaim, whichever is later. This inspection is of the opposite parties' documents. Every party has to submit a statement of admission of denials of all documents disclosed and to which inspection has been completed within 15 days of the completion of inspection or any later date as fixed by the court. Then order also contains provisions regarding production of documents, electronic record. So this is how this amendment has been brought in Order 11. And these provisions, generally it so happens that, the timelines are not adhered to. Otherwise, generally, appropriately, it should be if the timelines are followed, the possibility of the suit getting decided early, the chances are more. But generally it happens, and then court also follows this kind of ensuring that this kind of a procedure which need to be followed are strictly adhered to. There is one aspect also which is relevant insofar as the Commercial Courts Act is concerned, is the is summary judgment. We have heard Order 37 summary suits being filed. That's in a normal suit. We are in commercial disputes, commercial litigation. 37 is not incorporated for the purpose of commercial disputes. It's outside. But there has to be a provision where this kind of a provision which is akin to 37 be also provided for a purpose of commercial suit. With that view in mind, they have provided the provision of summary judgment. It says there was no specific provision of summary judgment earlier. Through this provision contained in Order 13A can be regarded as similar to Order 37, which lays down the procedure for summary suits. Summary judgment is given by the court without recording oral evidence, where the court considers that one of the parties does not have any real prospect of succeeding and there is no other compelling reason why the claim should not be so disposed of. Summary judgment may be in respect of a part of claim or any particular question on which the claim, whether whole or in part, depends, or counterclaim, as the case may be. An applicant may apply for summary judgment at any time after summons have been served on the defendant, but before issues have been framed in that suit. Where a hearing of a summary judgment is fixed, the respondent must be given at 30 days. These are all the procedures. So this is to say this, that if on the basis of the claim, if on the basis of the plaint and written statement, because issues have not been framed by that time, one is clear that whatever claim has been made need to be allowed on the basis of the party, because by the time when the plaint is filed, you have all the documents on record from the plaintiff side, you have a written statement, all the documents have been filed by the respondent, you have a clear picture. But that effort need to be made. You have a clear picture, where does the claim stand. If there is a possibility that the claim can be actually allowed, one can have resort to this provision of summary judgment. This is only to, to save time and for the disposal of a case, is that this provision has been given. Unlike 37, 30, leave to defend everything, that also is a summary in nature. But this provision is different from 37, but the intent is identical between 37 and the summary judgment. Now, I'll just show you one judgment. Yes, in this case, decreed the suit under Order 13A. The court was of the opinion that the defendant has no real prospect of defending the claim, and no other compelling reason appeared why the claim of the plaintiff should not be allowed. So permanent injunction was granted, restraining use of plaintiff's trademark. This is in such cases, I think possibly one can resort to summary judgment, and possibly, the case is finished. See, in trademark, what can be the defense? Defense is, if it is a registered trademark, there cannot be, the right is there with the registered holder, unless and until it is a case of passing off, where you need to look into the evidence, everything. Then, similar is the position in the next, the case at the bottom, KR Impex versus Punj Lloyd. So, at least till now, what is being provided, what has been provided by the Commercial Courts Act is, the dispute must be related to those disputes which are, stated in Section 2C, specified value. Then one is commercial disputes and other is specified value. How will you determine specified value? Anything above 3 lakhs would be construed as a specified value, and these two things must be necessary for the maintainability of a commercial suit. This is one. We have seen the mandatory provision for the filing of the written statement, the documents also. We have seen also the interrogatories, how to be filed, in what manner those to be dealt with. We have also seen the provisions of 12A, which contemplates a mandatory pre-litigation mediation process. We have also seen the cost that can be awarded. We have seen summary judgment. Now, there is a provision for case management hearing, that has been provided under Order 15A, which has been brought in the CPC. and by amending the CPC through the Commercial Courts Act. And which the intent of this case management hearing is time frames are fixed so that the case can be decided. The time frame can be fixed till the final arguments, and interestingly it says in any case arguments to be closed not later than 6 months from the date of first case management hearing. So that 6 months has been given as the upper time limit. Generally it doesn't happen that 6 months are realistically adhered to. I think the officers can say so. In how many cases 6 months have? I don't see, there is a load on the system. To say that to 6 months we can complete it, it's highly impossible. But don't take it that way. If you can do it, please do it. There is one thing, in fact, Madam Radha has said also, and I also felt, sitting in the jurisdiction, I'm seeing. This is pertaining to Arbitration Act. The 34 comes from the award of the learned arbitrator. I've seen, and this is only for you to just look into it and possibly make some correctional method. I have seen some judgments, 34 law is well settled. Scope is limited, it's not an appeal. Facts have been established by the learned arbitrator. The contract has been interpreted by the learned arbitrator. You would not interfere in 34. But what is sought to be said in some judgments is, oh look here, this is a petition under 34. Scope is limited, I'll dismiss it. That should not be there. Even Supreme Court in Associated Builders, I'm giving an example, Sangyong, every judgment has looked into the facts. See, what you have to do is, you have to translate that particular judgment or the law in the facts of each case. You will not say that 34 limited jurisdiction, I will not see it. You will see it in the facts of this case and then apply the law. That's how one should do it. But, oh, it's 34, I will not look at it, dismiss. That should not happen. Law is developed, you will see so, public violation, contrary to public policy, you will look at it and you will say, how is it contrary to public policy? Just say we have other patently illegal. You will say how it is patently illegal. See, there are certain heads which let me take that. Very well. You know all the grounds on 34. Under what circumstances the court can interfere. Patent illegality, public policy, and it's not following the provisions of the Arbitration Act, contrary to the procedure which has been stipulated in the contract. The invocation was not proper. All those things are there. But only request, while coming to these findings that this is the law and I hold that it's contrary to public policy, or it is contrary to natural justice, or contrary to natural justice, and there is a morality, I think morality ground is also there. So when you are determining it, please look into the facts, look into the law, translate the law or translate the facts to the law, and then come to a conclusion. Don't say that 34, I have no jurisdiction, I have a limited jurisdiction, I'll dismiss it. Don't say that. I've seen some judgments, well written, everything, but don't do this. See, this is how, otherwise what will do? The appeal will come, what? The first argument will be of the counsel is, what is this? 34, not looked into the facts of a particular case. It need to be looked into, the facts need to be linked into, the facts must be seen whether these facts lead to that conclusion, what has been held in Associated Builders or Sangyong, all those judgments, that need to be done. I think that should be looked into. So, well, I think a broad perspective of commercial courts is this. What I have said, what would be the commercial disputes, what would be the specified value, what kind of changes have been brought about through the Commercial Courts Act, amending the CPC only for the purpose of ensuring the objective of the Commercial Courts Act is met and the litigation is decided at the earliest. If you have any other questions, possibly we have other officers also who will answer your questions. How many years you have been sitting in the commercial court?
1 year.
1 year. Who have sat for 3 years or who have sat in the earlier jurisdiction? No, 3. Oh, Mr. Hegde, you have. Oh, yes, Mr. Hegde, you sat also, I know. So very well, you have a good, sufficient experience also looking at. 12? Yes.
12A contemplates an urgent relief under the Act. I don't find any relief provided under the Act. All the reliefs that are sought under Order 38 CPC 39 Rule 192. The Act doesn't contemplate any urgent relief. How it is interpreted is my question.
Very interestingly, 12A, when you are seeking pre-litigation mediation, must confine to a commercial dispute. That's right. If commercial dispute, that particular commercial dispute means specified value, and it's a commercial dispute under those provisions of 2(6). If it is yes, you will seek your remedy. See, what your question is, all the internal relief which are sought is under Order 38(5). Possibly, if you can make out a grounds for 38(5) and make averments in the plaint to the satisfaction of the court in terms of what the Supreme Court has said in Yamini Manohar, can be. It is not a case whether Order 38(5) would not be maintainable. It cannot be such.
Yes.
It can be maintainable in certain circumstances. The threshold is very high. Unlike 39(1) and 2, 38(5), the threshold is very high. So those parameters need to be fulfilled for you to get that 38(5).
One more question. One definition is ordinary disputes of merchants, bank transactions. Now, bank lends loan for educational purposes, agricultural purposes. There is some view that all suits filed by a bank should be transferred to the commercial. If that is the view taken, now when it comes to Section 34 CPC, the ceiling limit for further interest is 6%. In the case of a commercial transaction, it can exceed 6%. Now, if a suit is filed for recovery of the education loan lent or for growing of a crop, if at that stage we say that it is a commercial dispute and transfer it to the commercial court, when it comes to giving interest under 34, it would not be a commercial transaction because it has been given for a different purpose. This is one area which our
Although,
officers have always been in.
the terminology used in those definitions is merchant, bankers, financiers.
Yes.
What is contemplated is, although if a bank files a suit, if it is of a particular limit, then it will go to that, recovery of debt. But it appears to be something who is lending money.
Yes.
Lending money. It is in that context. But when it comes to banks filing a suit, is it a recovery suit filed by the bank or is it the person who has taken the loan who is filing the suit?
Bank. If the bank files a suit, some officers are of the view that every suit filed by a bank for recovery.
Well, you can give a try. I don't know whether it will come within the definition of banker or not. Strictly going by that terminology which is used, surely a banker. But at least the judgments which have come about is, the person who lends the money. It is in those eventualities this stipulation is there. Unless and until you can show any case where the bank has come as a commercial suit and sought money and that has been given.
Thank you.
We had this discussion earlier also when there was an online.
You had a dissenting view.
I had disagreed with my request person. Banks also lend money for buying vehicles, for marriage purpose and other things.
Personal loan,
Personal
loan, agricultural loan.
Everything. No, sir. Actually, what 21C1 says is ordinary transactions of bankers, merchants.
Yeah.
Lending is an ordinary transaction of the bank. So that being so, there is no reason for excluding educational loan recovery suit or agricultural loan recovery suit.
Very well. See, I'll tell you, there are judgments which says a hand loan. although a hand loan, which cannot be a subject matter of a commercial transaction. What is commercial in this? See, you have to see what is the core of that relationship.
My lord, in the case of hand loan, it may not be a bank and individual involved.
But the person,
Wherever it's between two individuals and a hand loan is lent, that is understandable. Here the bank is lending for...
possibly, I think you can say also, you can
please.
possibly, to my recollection, I think a financial institution under the, the local financial act, that state financial act also.
Yes.
Possibly, I think they have also approached the courts also for making a claim. Maybe on the ground of commercial dispute, I don't recollect it is a normal suit or a commercial suit also. One can make at least, do you have any precedents where the bank have come and has been entertained in the commercial courts?
I used to entertain those suits, my lord, as a commercial court judge, yes. Thank you.
But at least surely High Court has not set aside on that ground?
Not.
That's enough.
Probably those judgments were not challenged by the borrower and...
As long as those judgments stands, the jurisdiction is there.
Oh, please, my lord, thank you.
Good evening, Your Lordships.
Though the banker is defined there, the whole idea of understanding what is a commercial dispute under section 2(1)(c), the nature of dispute is to be seen.
Exactly.
That is the only thing that would come, whereby
The nature of dispute,
home sector, as what had is there, agriculture, how can it be construed as a commercial? Right away. To entertain such suits, then what about the civil suit? And what about the civil court? What about the debt recovery tribunal?
yeah, because those have jurisdictions. And mind it,
There is an interplay between DRT and the commercial court and the civil. Civil courts are barred under 31.
very right. Even here, the jurisdiction of civil court is barred. So akin to civil court, even commercial court, it would be barred.
That's the logic.
It has to be, you have to see what is the court dispute relating to the business relationship it has. That is what need to be seen. It depends upon the plaintiff, it depends upon the mercantile documents. If you see that C contemplates interpretations of those mercantile documents. They are there. In fact, there is one judgment, I think Gujarat or Bombay, where there was a particular kind of a document which was construed to be a mercantile document, and they have entertained it. It depends upon the contents of the documents, many aspects of it. It's a question of fact based on the evidence, based on the interpretations of the document. That's the reason 2C contemplates even interpretation of mercantile documents.
Your Lordships, one small question. When there's a transfer of petition from the original jurisdiction to the commercial court, it goes de novo. So the entire object of the commercial court is to finish the litigation in time.
You are referring to section 15.
Yes, Your Lordship. And even the question of definition of a mercantile document, when there's also a dispute whether a check is a mercantile document.
Very well. That's a subject matter of interpretation, you know that.
And a question of a de novo proceedings will, again, the objective of a commercial court.
But is there no relaxation in that eventuality? Or you may have to, the rigors of the commercial, the rigors of, the affidavit, statement of truths, you are saying so about that?
Right.
It should be de novo.
No, it's already de novo. There's a transfer, it becomes de novo. So
yes.
Again, the question, the object of commercial court where it has to be done at a time frame. So again, it has to go at a long...
You're right. But the sanctity of the commercial dispute need to be maintained, na? It is by incorporating these provisions, there is a sanctity to those dispute, these kind of a disputes. Possibly with that view, they may have incorporated it. Getting it? See, that's the reason statement of truth. It was not there earlier. Affidavit, and those things, and admission denial by affidavit. Previously, it was not there. Even at the filing of the written statement, you have to file it. So maybe to keep the sanctity of the intent of the Commercial Courts Act, possibly this has been done.
My lord, in case of a transfer, it won't be a de novo trial. Because
to my recollection,
Section 15, there's a provision which says...
relaxation?
Yes, my lord. It says the trial should continue from the stage at which it is transferred.
That's right. See, you may be right. Ultimately, when a suit has been filed, the case has reached at a particular stage. Why a de novo? To my recollection, what just Ms. Radha has said also, it appears there is some relaxation which has been given. It appears possibly.
Section 12A, I'm telling.
May I read, my lord? Where any suit or application, including an application under Arbitration and Conciliation Act, relating to a commercial dispute of specified value shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures that were not complete at the time of transfer. The commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further direction as may be necessary for a speedy and efficacious disposal of such suit or application in accordance with Order 15A of the court.
Much would depend upon what is the stage on
At which it is transferred. Where it is at the stage of written statement, the provision says that even new timelines can be fixed. For written
Good evening, my
statement.
lord. I have a practical problem, practical difficulty. I faced very recently, I faced in my court, civil court.
Pardon?
Good evening, my lord.
Yes, yes.
Good evening. I faced one very recently, I faced one practical difficulty which I would like to throw before the Honorable August Forum. In a case where a suit is decreed and an execution petition is being filed. Execution petition is being filed by a decree holder. Now the judgment debtor comes before the court and he takes the defense of commercial courts. He says that the said suit is, execution is not maintainable for want of jurisdiction.
Penalty.
Yes. And I just posed a question. Does it not amount to acquiescence of the waiver of the jurisdiction? Because you are supposed to take at the onset of the filing of the suit. But you have not taken such defense, and how it is maintainable in the execution proceedings. So this practical difficulty which I faced very recently, so I wish I thought
Let's ask the officers here. What is your take on that?
highly obliged, my lord. Still I've kept it for...
Mr. Somshekhar? See, the principles, although it's a nullity, and to what extent you can seek an execution of that judgment, it's an interesting point. But can there be an acquiescence when in-law, that's a commercial dispute? Whether in-law is a commercial dispute, can there be an acquisition? Yes, Mr. Somshekhar.
Lack of initial jurisdiction. Any judgment ultimately would be quorum non-judice. So therefore, that can be raised during execution proceedings also. I think that's the settled position.
Now, otherwise, I don't know, in Karnataka, when such an objection is taken, is a trial is taken, trial is held?
No, at the initial stage, in the very jurisdiction of the initial inherent jurisdiction.
No, I got it.
Yes.
It's a quorum non-judice, it's a nullity in that sense.
After the decree, even during execution
But there are judgments which say, sir, you can't go beyond the decree.
But the inherent lack of jurisdiction, that would be
raised.
47 provides for that.
That's right. Can be, but if that's right. That's the point. There can't be an acquisition against a statutory provision which defines a commercial dispute. It can be raised. I don't know what happened in that case. See, it's a nullity, surely at the execution stage can be looked into. And if you feel that the executing court, the difficulty is what would be the jurisdiction of the court, executing court, for holding it as a nullity. And then what follows? Dismiss the execution petition?
My lord, what he would, the learned counsel would like to emphasize is that as good as amendment proceedings, like if an amendment can be brought even in execution petition, even in an appeal, and similarly even in execution, we can also bring this into bring to the home. That is his contention.
Amendment to what?
just like as in the parallel footings, like how we plead an amendment in execution proceedings and also in appeal, in the same fashion, I am bringing this to the court that we can file an application on the point of jurisdiction. This is very recently, it is filed, execution is filed, so I am doing a thorough search and homework. So
Very well, what has been suggested, inherent lack of jurisdiction, it's a nullity only. And possibly you will look into the law on that aspect. If it is there, the consequence would be the execution petition would not be maintainable that way. Getting the...
highly obliged. Highly, thank you.
Subsequently, it was not transferred to the commercial. It is not inherent as
No?
that is only for pending suits.
That's right.
After establishment of the commercial code,
Oh.
suits are
See, can be a provision under 710 can be utilized. 710, you return the plaint, ask him to go there.
the suits are transferred.
Well, it doesn't make any difference. 710, you return the plaint, ask him to present it before the competent court.
Well, he is not a device. Well, he is mandatory measure in order to avoid the procedure.
Okay. No, why 12A? No, why just come again on that? What did you say? No, he files a suit.
Say, who is that, to file a suit to the ordinary civil code. Then it is seek for transfer of the
You can also return the suit stating that
I think best would be, I think, very in such an eventuality, maybe, but 710 is optimum, appropriate. 710, give the return it and ask him to present in the competent court. That's the way.
commercial code as well as the civil code are coming under one extra. They prefer to get the case transferred without returning the pay, so that the court fee payment all come under one establishment. No, when you return the client, court fee is also returned. Yes.
Yeah.
Advocate seems for transfer without return of claim, so that they need not file once again.
See, I don't know. See, normal suit may not be filed with a statement of truth, affidavits, everything. Once he is filing a commercial suit, he has to follow all those formalities. So how can it be transferred?
Yes.
They are inadvertently for the suit because when once defendant raises an objection or else they start thinking that it is a commercial transaction, then they will file an application to transfer, and inadvertently they are also transferring the suits directly.
See, that need to be looked into. If all the requirement of a commercial suits are satisfied, if you are transferring it, then what will happen? What is lacking in the commercial suit? Must be the statement of truth may not be there in the original normal suit. These may not be there. So, if that is so appropriate, would be ask him to do it. Whatever is the deficiency, he will make it out before the commercial court.
Yes, it is better to return claim.
It's there. There are judgments on that. There are judgments on that return of the plaint. Anything else?
Recognized IT professionals is required for the seizure of data and computer information, drawings and other things in case of trademark and other case. We can appoint only in Hyderabad, that is the one agency. And some advocates are disputing and they are submitting other names. And some only dispute is arising for the appointment of IT professionals.
It's like a commissioner only to be appointed by the court. You are within your rights. You can take an expert. There are so many experts would be available.
IT professionals, we cannot have any list to show that we can appoint.
No, can't you appoint an IT professional recognized?
They are disputing the two professionals. They have suggested.
You can appoint an NIC officer. what is there as a commissioner?
Yes.
He's an IT professional. You can appoint him. You have to appoint a commissioner only. And NIC, government, what else you want? That's all. Thank you very much.
My Lord,
yes.
A small clarification. 12A says pre-institution mediation is a must. And the apex court in Patil automation says if it doesn't comply with it, it shall be a rejection of the plaint under Order 7, Rule 11. And Yamini Manohar, it says you have to see the facts in each and every case and then arrive. Now, suppose if at the first hearing in the fresh suit, the court feels that 12A is to be complied with. Are we right in returning the plaint for complying 12A and then represent the plaint?
So you can do that, but otherwise no prejudice is going to be caused. That period is in any case excluded for the purpose of, computing the limit. It doesn't make, even if you don't return the plaint, you say, I am dismissing it, go there, comply with 12A and then come. He will get excluded. Limitation would not make any difference.
Yes.
You're getting the point?
Return of the plaint. Because if we reject the plaint or dismiss it, he may lose the court fees.
See, I think 12A has some, purpose. Purpose is the 12A must be uninfluenced by any litigation which is pending. Why should it be kept pending? Or you want to return it? So he will not go with an open mind. He say, look here, the plaint has been returned. In any case, if it is dismissed, I can go back. Let him go back with an open mind. And why I am saying is no prejudice is going to be caused. Even if you say dismiss, 12A has not been complied with, go fulfill 12A. If you don't succeed in 12A, come back. The limitation is excluded. To that extent, no prejudice. You are talking of court fee.
Court fee, yes.
In any case, what Justice Ishananda has said, in any case, the court fee would be returned when the plaint is being returned.
Yes.
What prejudice?
Dismissing the suit. We are not returning the...
dismissing the suit.
7 Rule 11, if we are rejecting the plaint, then he will lose the court fee also.
That he can.
Yes, sir.
Keep the suit pending.
Yes, madam.
Direct the parties to exhaust the remedy under 12A. Come back.
And mind it, there are judgments.
Yes.
You can't dismiss it.
Yes.
You maybe possibly at the most can return it, but you can't dismiss in a suit. But you can say so very well. Go comply with the 12A and then come back and then file it. No prejudice is going to be caused to him that way.
Thank you.
For return of court fee. Oh, under 80, section 8. Okay. But I don't think in that eventuality, there should be, ultimately court say very well, go 12A, go and come back, no prejudice. Why should not be, that procedure may be adopted? Reject the plaint. Because it's a mandatory nature of the provision 12A. So you need to comply with it. But will that preclude you after the dismissal of the rejection of the conciliation failing that he can't come back and file a suit?
My lord, he can file a suit, but then once the plaint gets rejected, court fee will not be refunded. After exhausting pre-mediation, he'll have to come back, pay fresh court fee and...
Okay, you're right, Patil. Insofar as Patil is rejection of the suit, go comply with 12A and then come back, but no return of court fee.
Court fee. He'll have to pay fresh court fee.
Ask your scrutiny clerk to find out whether 12A has been complied. Before registering the suit, give a hearing. Tell him that you lose the court fee by party. You want to go and then exact and come back. That you can do it. Same is the question for them also. If the suit is filed, if it is of commercial nature, scrutiny clerk will look into and then say return. I don't have jurisdiction.
No, brother, generally what happens is to avoid 12A, they file a suit.
No, then they will have to pay the price, that's all.
Well, this in fact we had done in the Bengaluru Commercial Court. We had put it up on the notice board immediately after Patil automation case that the law mandates this. If you don't comply section 12A, you will lose the court fee and the plaint will get rejected. Parties have been complying with that.
Unless and until there is something which is urgent relief is sought. Thank you very much.
Of the Act. As you conclude the day's program, it is time to express our gratitude to everyone who have made the event possible. May I now request Honorable Sri Justice Sunil Dutt Yadav, Judge High Court of Karnataka and Governor Karnataka Judicial Academy to deliver the vote of thanks. Please.
Respected Chief Justice, Honorable Justice V. Kameswar Rao, colleague, brother and sister judges, registrars, staff and all present. It's indeed a heartening moment personally for me, for it's very rare that we express gratitude for somebody who is close to us. It always happens that we do it for others. So this is a occasion where we are expressing gratitude to a elder family member, and that's why I would attach all importance for it. It was an insightful speech and a classic example of how to simplify. So we need to understand that even when we speak to legal professionals and judges, we need to simplify. And I think Professor has done a good job.
You are changing my profession, huh?
So I extend heartfelt thanks to the President, fellow governors of the Academy, all the brother and sister judges who have been present here, the Registrar General and other registrars, Director of Faculty, presiding officers of the commercial courts, and members of the district judiciary. It was an interesting lecture that exposed us to the basics and also has provoked us with many questions that still remain unresolved. And I thank you, and we look forward for the next lecture. Thank you. I thank the Chief Justice for his patient presence, and I would like to state that there's one remarkable feature of the Chief that we as brother judges find, that his presence is noticed, but it merges with the crowd, and that's the unique feature of our Chief Justice, who's present everywhere but does not force himself in any manner. Thank you.
Thank you, my lord. On behalf of everyone, I extend heartfelt gratitude to Honorable Sri Justice Sunil Dutt Yadav, Judge High Court of Karnataka and Governor Karnataka Judicial Academy. Thank you all. Thank you once again. Thank you all.